Good morning, everybody. Welcome to today's webinar. My name is Bob Teasdale. Perhaps spoken to some of you before. I'm the Customer Engagement Director here at MyHR Toolkit. I'd like to welcome to today's webinar. We've been running a few sessions recently on things that impact SMEs on different HR and business topics, and like this one, they've been very popular. We've got over 50 people tuned in today to find out a little more about dismissals. We'll come on to that shortly. So welcome to you all. Today's area is dismissals. No one likes doing them, and frankly, even less people like doing them or want to do them. But from time to time, they are necessary, and in some cases, actually the best thing for the employee themselves. So what's important is if we do have to do them, that we're fair, that we do them right, and the business benefits. Hopefully at the end of today's session, we'll have time for some questions. So please put those in the Q&A box, which is on my screen, it's at the bottom, I think it generally is, rather than the chat area, because we sometimes miss those. So if you have any questions, put them in the Q&A area. Just before we get going, I'd like to clarify that, as always, today's session is providing general HR advice, and in no way should it be construed as legal advice. I need to make that clear. We'll be hosting another webinar in 2 weeks' time. We're looking at the increasingly contentious issue of, can you compel employees to have a COVID vaccine? Not quite started giving the younger generation, younger people vaccines yet, but that's going to come, and the advice seems to change every day. So in a couple of weeks, we'll be running a session to perhaps shed a bit of light on that. But for now, focusing on dismissals, I'm very pleased to welcome a HR specialist from our friends at Howarths, specialist HR and employment law business in West Yorkshire. I'd like to welcome Wendy Cresswell. Wendy, good morning.
Good morning, Bob. Welcome everyone, and thank you, Bob, for the introduction there. I've only done a few webinars like this, so each time I get really nervous, so please just bear with me on that. So my name's Wendy Cresswell. I've worked for Howarths as an HR and employment law advisor since October 2018. I'm level 7 HRM qualified, and I've got over 6 years experience in HR and employment law. At Howarths, we give advice and support to SME businesses from various industries, both from the public and private sectors. And that's on all aspects of HR and employment law. But we also provide on-site support as well. So this might be, for example, leading on formal meetings. So that's a bit about me and about Howarths. As Bob said, today's webinar is about dismissal. I'm going to talk about both fair and unfair dismissal. So the areas I'm going to be covering today are the fair reasons for dismissal, automatically unfair dismissal. I'm going to navigate you through a tribunal claim. We're going to talk about discrimination, constructive dismissal and breach of contract. One bit around subject access requests, and also about probationary periods. So at the end of the webinar, I'll also have a couple of case studies to share with you as well. So the webinar itself, depending on how quickly I speak, will take about 30 minutes approximately. And at the end, we've slotted in some time for some questions. But as Bob said, if you've got any questions during the webinar, please just put them in the Q&A box, and Bob will prompt me. Okay. So I thought a good place to start was to talk about what constitutes fair dismissal. For a dismissal to be fair, the employer has to show that the employee was dismissed for one of the following 5 permitted reasons. These are capability, conduct, redundancy, statutory illegality, and some other substantial reason. So if we start by looking at capability, it falls into 3 categories. that is qualifications, poor performance and ill health. Where poor performance is relied on as a reason, a dismissal is likely to be unfair unless a capability procedure aimed at bringing the inadequate performance to the employee's attention and giving him or her the opportunity to improve has been followed. Conduct issues range from failure to follow lawful instructions to engaging in activities outside the workplace that damage the employment relationship. An employee can dismiss in misconduct cases even if the reason does not amount to gross misconduct, but is obliged to give notice and follow a procedure including warnings which are fair overall. For example, if you were dealing with a minor first offence of misconduct, it's most likely that a reasonable warning would be a first written warning, and it could be seen as unreasonable to go straight to a final written warning for a first offence, unless you can substantiate the seriousness and you can evidence it was reasonable under the circumstances. Okay. Where there's been gross misconduct, no notice needs to be given, but a fair procedure must be followed. Redundancy dismissals may be unfair where there's a failure to follow an appropriate procedure. This could be because the employee's failed to adequately consult with the employee, has followed an unfair selection procedure, or has failed to consider alternative employment. Statutory illegality occurs if the employee could not continue working in the position without contravening a duty or restriction. So, for example, that might be something like a bus driver who loses his or her driving licence and cannot continue to drive. However, in such a case, an employer might be required to consider whether there's any reasonable alternative non-driving work that could be offered for the duration of the driving ban. Some other substantial reason is a catch-all category, which provides a potentially fair reason for dismissal where the circumstances cannot be classed as one of the other potentially fair reasons. So the following could amount to an SOSR dismissal: the dismissal of a person employed on a temporary replacement, the dismissal of an employee who's been imprisoned, dismissal resulting from the employer losing trust and confidence in the employee because of something that they've done outside the workplace. If an employer can show that the dismissal was for one of the fair reasons, whether or not it was fair or unfair depends on whether the employer acted reasonably or unreasonably in treating the reason as sufficient for dismissing the employee. A tribunal will take the size and admin resources of the employer into account, and depending on the circumstances, factors could be relevant, and this would include things like whether the ACAS code had been followed. So in cases of unfair dismissal, awards can be uplifted by 25% if the code has not been followed. It also take into account the length of service. So if you've got an employee who's got a number of years service and the conduct was out of character, for example, it'd be more reasonable to be a little bit more lenient. They'd also take into account the reasonableness and thoroughness of any investigation. You know, one thing you need to evidence is that it's not just one-sided against the employee and that facts have been gathered to support their defence as well. They'd look at the extent to which the employee was warned and given the opportunity to improve, the extent to which the employee was given the opportunity to give his or her version of events before a decision was to dismiss was taken, consistency of treatment with other employees. For example, someone who's committed the same offence previously and has had no warning, but then you give somebody a final written for exactly the same thing, could be seen as unfair. And lastly, whether the employee was considered for other roles within the organisation. The employee's actions will be judged on the basis of information that was available to it at the time. We talked earlier about exceptions to the rule. We're going to now talk about automatically unfair dismissal. If the dismissal is for one of the automatically unfair reasons, no qualifying service is required to bring a claim. And these would be things like taking action on health and safety grounds, asserting statutory rights, reasons related to pregnancy or maternity leave, refusal to work over 48 hours a week under the working time regs, making a protected disclosure, so that's whistleblowing, or making a flexible working request. Okay, so we're just going to go on to talk about tribunal claims now. So a likely time frame from start to finish for a tribunal claim may fall between 6 and 18 months. If any employee wants to make a claim to a tribunal, they have to firstly inform ACAS of their claim within a statutory timescale. That's normally within 3 months of the dismissal, but it does vary depending on the claim. And ACAS can assist in settling, seeking settlement for up to 6 weeks. How long ACAS assists in seeking settlement will depend on how willing the parties are to negotiate. If the employee does agree to settle, then no claim is issued to the tribunal. If it doesn't settle, the claimant will then have to lodge their claim form with the tribunal within the relevant timescales. Again, it can vary. How a tribunal case is navigated depends on the type of claim being made. Every case is dealt with based on the specific needs of that matter, taking into consideration not just the legal claims, but also the parties involved. There are some steps, though, that will be common to virtually all tribunal cases, and the following would have to happen in order to fully prepare the case for a hearing. Claim form is issued to the tribunal by the claimant. The respondent has 28 days to lodge their defence. The claimant will provide a schedule of loss outlining the compensation they're seeking and how it's calculated. Each party will provide the other with copies of documents they hold so that both sides have sight of the documentary evidence. This is called disclosure, and both parties are under a duty to carry out a reasonable search and disclose all documents that are relevant to the claim, whether they support their case or not. A joint bundle of documents has to be prepared, which is a file containing every document that will be referred to at the hearing. It often falls to the respondent to prepare the bundle because of the availability of resources, but that's not a given. Every witness will give evidence at a hearing, must provide a written statement containing all their main evidence. Each witness will prepare their statement, and then usually at the same time, the parties will swap statements. This is called statement exchange. And the purpose is to ensure that both sides know what the main witness evidence is going to be ahead of the hearing. The witness statement will be read at the hearing and taken as the witness's main evidence. The hearing will take place at the tribunal and the judge will make a decision on the claims. Parties don't have to be represented by a lawyer at the tribunal hearing and can represent themselves. It's not uncommon for claimants to represent themselves rather than have a solicitor or a barrister present because of the cost. Just looking at the types of awards as well for unfair dismissal. Compensation has 2 types of award. There's the basic award, which is the same as a statutory redundancy payment, and a compensatory award, which is capped at the lower of 1 year's salary or just over 88,000. A compensatory award can vary from case to case as there are many different factors how they calculate compensation and a number of ways that compensation can be reduced. Just have a drink of water. Okay, so just going to talk a little bit about discrimination. So the Equality Act 2010 provides protection against unlawful discrimination, harassment and victimisation for the protected characters listed, which are age, disability, gender reassignment, marriage and civil partnership, pregnancy and maternity, race, religion and belief, sex and sexual orientation. Where someone believes they've been dismissed because of a protected characteristic, it may give rise to a discrimination claim. And it can in some cases also be automatically unfair if it's for the reason I discussed earlier, and either claim can be made irrespective of length of service. Okay, so we're just going to go on now to talk a bit about breach of contract and constructive dismissal. When could an employee claim a breach of contract through the dismissal process? Well, irrespective of length of service, the company's policies are contractual and you don't follow a process when looking to dismiss, then if they've got under 2 years service, they can't claim ordinary unfair dismissal, but would put in a breach of contract claim for failure to follow such contractual procedures. A constructive dismissal occurs where the employee resigns in response to conduct by the employer that amounts to a repudiatory breach of contract. So this would be something like enforcing changes of terms and conditions without getting consent from the employee. But to make a successful constructive dismissal claim, they must have over 2 years service. The next point I just wanted to make isn't directly linked to unfair dismissal, but it is something to consider. Complications may arise if you look to dismiss somebody without following a process, feel unfairly treated, you've got a disgruntled ex-employee out there to seek revenge. And they may decide to put in a subject access request. This in itself is a timely exercise. So irrespective of length of service, just to avoid such unnecessary resource, we always say it's just best to follow the process. I think as well on another point, we've also got the fact that social media is out there. You think about Indeed, where employees can put comments on about their employers. And this can obviously have a detrimental impact on business reputation. So again, at Howarths, we'd always say follow a process irrespective of length of service. Right, so it's common to have probationary periods in your contracts because it allows some flexibility to dismiss somebody who's not working out in those first early months. If you are looking to dismiss somebody within a probationary period, it's a lot more flexible than when the probation is completed successfully. However, again, considering whether procedures are contractual, there's still a risk of a breach of contract claim, so you should always be confident of your obligations. Not only that, from April last year, employees have to set out any specific terms that they want applied during the probationary period. For example, different or earlier termination. Otherwise, this again could give rise to a breach of contract claim. Where procedures are non-contractual, you have choices on how you deal with performance and conduct within a probationary period. From an extreme best practice point of view, we'd always suggest that if you're considering dismissal, actually do it face-to-face in a probation review setting, discuss your concerns and allow the employee to respond. The main points really is trying to establish whether it is conduct or capability. And it will be a choice whether you allowed somebody to be accompanied, also whether you invited them to a review in writing or just bring them into a meeting. From a capability point of view, you'd have two options really. You'd look at whether you wanted to extend the probation and give the employee the opportunity to improve. For example, putting a performance improvement plan in place. And we'd say that that would be advisable. But you should also make sure that you've got the provision to extend the probation in the contract. Otherwise, it could be a breach. And also, how long you're going to extend for. It would be reasonable to suggest an extension for around 3 months. The alternate to that would be you could dismiss on the grounds of failed probation, and that can be done at any point during the probation period. When deciding on any action on the back of the review, again, you can meet face-to-face or just write out with an outcome. If you are looking to dismiss, would it be fair to offer the right to appeal like you would do when somebody's got over 2 years service? I mean, that would be your choice. It can actually be useful. It gives you an opportunity to see what line of attack the employee might be considering and to rule out any risks at all. From a conduct perspective, you should consider whether you follow a disciplinary process or not during probation. Of course, you can look to dismiss without following a process. Check your disciplinary policy. Some people do have disciplinary policies that are contractual. and look at any clauses in the contract that may mean that you could be at risk of breach of contract if you don't follow a procedure. Another point to consider is, would it be fair really to dismiss somebody at least without having an investigation fact find meeting, because it could be that there are mitigating circumstances. Once someone has completed the probation and passed, still got under 2 years service, you can no longer rely on the flexibility of terminating for failed probation. Yes, you can still decide not to follow a process if the processes are in fact non-contractual. Someone cannot claim ordinary unfair dismissal with under 2 years service. However, the risk of discrimination could still be there. In conduct cases, we would always advise to follow the process in line with ACAS best practice, which in essence is a thorough and fair investigation, the right to 48 hours notice for a hearing, and the right to be accompanied at any formal hearing, and the right to appeal. The code also outlines impartiality during each stage of a disciplinary process. For example, it would go up in seniority with a different person at each stage. So you might have a line manager conducting the investigation, a more senior manager chairing the disciplinary, and so on for the appeal. So irrespective of whether someone is in the probationary period or still under 2 years, employees have the right to be given a written reason for their dismissal, irrespective of whether a process is being followed or not, so as not to risk a breach of contract. If someone does appeal and it's successful and it results in a reinstatement, it may give them continuous service, because if following their reinstatement the employee chooses to resign because of the original dismissal, this could tip them over the 2-year mark with the ability to bring it in a claim for constructive unfair dismissal. Okay, well, we're nearly at the end now. I've just got a couple of case studies to go through with you, and then we can maybe go through some questions. So the first example was a recruitment consultancy manager. It was summarily dismissed for gross misconduct just 2 days before they'd had 2 years continuous service, needing to bring a claim for unfair dismissal. The employee did not follow a disciplinary policy, and the employee was not given the right to appeal. The employee claimed unfair dismissal. The tribunal had to decide if they had the 2 years continuity of service, needing to bring the claim. Employees can normally add on the statutory minimum period of notice to the effective date of termination if the employee is not given them the proper period of notice. The tribunal said that they should have had 1 week statutory notice. The unfair dismissal claim could proceed, and then the employer had acted unreasonably. The employer failed to investigate the alleged misconduct and follow a proper procedure before the dismissal. Okay, the other example is an employee was dismissed in a letter which was sent by special delivery and signed for by her son. It gives the date, it's probably irrelevant, but 30th of November 2006. She had been expecting the letter to arrive, but she'd had to go away for a few days because her sister was giving birth. She did not open the letter and find out about the decision until the 4th of December. She brought a claim for unfair dismissal on the 2nd of March the following year. If the effective dismissal date was the 30th of November, a claim would have been out of time. But if it was the 4th of December, it would have been within the statutory timescale. The Supreme Court held that the effective dismissal date was the 4th of December when the employee opened the letter. She should not be criticised for letting a letter stay at home unopened instead of getting a son to open it and read it to her as the contents were private. She had not deliberately failed to open the letter or gone away to avoid reading it, and therefore the dismissal date should be the 4th of December when she found out about the decision. The Supreme Court also held that on policy grounds it was desirable to favour the employee in interpreting time limit provisions, and that the strict contractual laws concerning concerning contract termination should not displace the statutory framework. Okay, sorry, a lot of information to take in there. We're at the end of the webinar now. I hope everybody's found it useful. I'm going to pass back over to Bob, and we can look at any questions that have come through that I can answer, hopefully.
Thank you very much for that, Wendy. We have indeed had quite a few questions, so let's launch straight into them. First one's from Abby. She was out of the blocks just after you started talking, so you must have hit the mark. We recently had a member of staff become aggressive to their manager, shouting and screaming down the phone. After it happened, the employee was signed off sick for 3 weeks and has now returned. Where do we stand?
Okay. If we're looking at a conduct issue, again, talking about following a process, first thing to do is a fact find. So if they've returned back from work, and I don't know whether any return to work meetings been done on the back of the absence, if it hasn't, I'd certainly do a return to work meeting, and then I'd pose the conduct issue to them. Fact finding meeting, you don't have to give somebody notice, you don't have to put it in writing, and they don't have the right to be accompanied. So I would be speaking to them about the way they spoke to the line manager on the phone and give them the opportunity to respond. I'd have somebody in taking notes, because if it were to go to a disciplinary, those notes from that meeting would be used as evidence. And really it depends on the responses, but it does sound as though it would be a misconduct issue, and it would follow a formal disciplinary process. Okay.
Right. Okay, thank you very much. Nikki asks, with regards to performance, is there a set amount of time the employer has to be employed by, e.g. 4 weeks?
So I'm presuming...
I mean, performance dismissal, I think.
Okay, I mean, I suppose it'll depend on the circumstance. If somebody has been, maybe they're clearly not right for that role, or they've been given support and training and they're just not getting it. There is certainly no limit. As I said, the flexibility is there during that probationary period. So you can dismiss at any time. I think it's more from a fairness point of view. So would you really be looking at dismissing somebody after 4 weeks because of performance? I think you've got to look at whether you've given them enough opportunity, you've given them enough support, and they've had adequate training.
Right.
Yeah.
Okay, thank you. Laura asks us, in a redundancy situation, is alternative employment only the open vacancies you have, or can someone claim based on the fact that you didn't bump an employee from another team? Are you bound to find the redundant employee a role even if there are no vacancies? Okay,
so you don't have to make up a role. It's basically reasonable alternative employment. So if you could find them something and it was appropriate, otherwise it would be what is vacant at the time. But you're under an obligation to make sure you've at least explored all avenues before you look to make somebody redundant.
Right, so you're not obliged to make up a job, but you've got to be pretty sure that you had a good look.
Yes, absolutely.
Okay. Joe says, can you explain a bit about probation terms from April 2020?
Okay, so under the new legislation, for example, there are things like explaining what will happen when their probation period ends. that you will put something in writing to them. There's not absolutely loads of content, but you have to be absolutely clear about how long you would extend a period extend the period of probation for, when the fact that you have got the right to terminate within that probationary period. Hopefully that answers it.
Okay.
Yeah, there is a bit around training as well within a probationary period and what would be expected to get, and also if after their probation is completed, what benefits they would be provided with.
Right. Yeah. Okay. Thank you. Very sort of topical question here from Nick. With the current situation of working from home, would you always have to set up a Zoom to complete the normal formality of review or any other conduct?
No, not necessarily. I mean, obviously we're in the climate that we're in at the moment, you know, and before the whole pandemic, we would have always said any type of meeting should be face to face. We know that's not possible because the government are saying if you can work from home, work from home. So the next best option would be a video call, but we know that some employees might not have the technology. So if it had to be a call, it had to be a call, but obviously not an ideal situation under those circumstances. I think you've got to look at what's available for you depending on the situation.
Yeah, we're all adapting.
Yeah.
Jane asks us, what would your advice be in relation to an employee who is recovering from a mental health illness? The concerns with the employer on the grounds of capability and not being able to meet the reduced targets given. We've provided counselling, reduced workload and gradual return to work. What would your advice be on the next steps? Okay,
I mean, this could be a formal capability situation, but what we've got to remember is depending on the person's condition, it could be defined as a disability. It sounds as though there are some reasonable adjustments that have been made, and that's an obligation on the employer. But if we were looking at going down a capability route, then you will need to be able to evidence that you've sought medical advice. My advice on this one would be to get an occupational health referral done, because an OH advisor would ultimately focus on the role and what adjustments can be put in place and advice on whether they are actually going to be capable of doing that role for the foreseeable future. Once you've got that evidence and you've spoken to the employee, if there is nothing else that can be done and they're still not able to do the role, then ultimately it would be a formal capability and it could result in dismissal.
Right, okay. Hopefully that was useful, Jane. Tracy says, I'll read it. She says, "Hi, sorry, I missed the right to appeal on the. I missed a bit. I've got regarding the right to appeal on the probationary period. Is this best to be put in the contracts such that they have no right to appeal prior to passing probation?"
It's a funny thing, but what you don't want to be doing is overloading the contracts. That would be better in probably in the handbook somewhere, if that was the case. But ultimately, you're under no obligation to give them the right to appeal in a probation period. So it's probably not something that you need to even consider. I think my point on that was that it can be useful to give them the right to appeal, because if there's something that wasn't disclosed in the review meeting, that could amount to discrimination, at least you get a bit of an angle on whether the employee's thinking about seeking anything, and closing down those lines of attack at that stage.
Right. Okay, thank you. A few people have contacted us asking, are we sending the slides out and a recording out? Well, the eagle-eyed amongst you'll have noticed we haven't run with very many slides today, but I know we will be sending a recording out. But a few of you have asked, could we send out a little bit more background, because you found it very useful. So after the session, I will liaise with Wendy and see if we can twist her arm a little bit, and we'll provide a little bit of content for you.
Yeah, I've definitely got some slides. There were just a couple of the subjects that I've not added, so I just need a bit of time to add something in around the tribunals and constructive dismissal. But other than that, all the slides are there, and I'm happy for them to be shared.
Thank you. That's probably the most live arm twisting I've ever took part in. So thank you. So okay. Those of you, we'll get that sorted for you today, tomorrow. We'll get those out to you. A few more questions. Andrea asks, if someone has signed a contract for an offer of employment, but never actually started employment on the agreed date and has given lots of different excuses why they're not starting. I've had this. The company then makes a decision to withdraw the offer. The person isn't happy as they now want to start the role. Do they have a right to ask the company for a notice period's pay, even though they never actually started?
Well, they could put in a claim. The most they would get would be the statutory notice. So my advice would be, if you want to withdraw it to avoid any such a claim, then yeah, it may be a week's pay, because that's really all they can claim at that stage.
So if somebody doesn't start on the date, the start date on a contract isn't quite as binding as you might think. It's not take it or leave it. It's
well, I mean, as soon as you enter into a contract, there is a contract there. So, you know, once you've put that contract in place, I'm not sure why. I probably need a bit more information about that. Maybe that's a separate conversation. Maybe follow up with an email to me, just so I can understand that a little bit better. I don't think I've got enough background on that one, I'm afraid.
Andrew, if you want to, there you have it. If you want to drop me a line, get in touch with my HR toolkit. I'll put you in touch with Wendy, and she'll explore that a little bit more with you. I'm really interested myself. I say I had an employee who prevaricated, and in the end they didn't start, but there was more to it than that.
Yeah.
So get in touch, Andrew, and we'll connect you up. On the right to appeal, and around the right to appeal question, after the probationary period, is the right to appeal automatic in all of the situations?
Okay, so for best practice, it would be, if you looked at the ACAS code best practice, and you need to check your policies as well to see if it was in there, for example, in your disciplinary policy. But from a point of view of a fair process, when we talk about a dismissal case, then if they've got under 2 years service and you don't give them the right to appeal because they still can't claim ordinary unfair dismissal, I think it's more from a best practice point of view and fairness, really, just to see if there is anything that's been missed that you maybe need to consider. Okay, thank you. We're going to take about another 10 minutes of questions, and we might, if you've not asked yours yet, we might be able to squeeze them in. So another couple of questions. If you want to submit them, we'll see if we can get around to them. If an employee is not entitled to bring someone with them to a meeting, but they request this, do we have to allow it? Okay, so I think this would be an investigation meeting, because that would be the only point where they didn't have the right to be accompanied. Up to you, really, because yes, you're not under any obligation to allow them, and they're only allowed to bring a trade union representative or a work colleague. But to be honest, it depends on the circumstances. I've allowed people's spouses to be there as a companion, and that was probably in a long-term absence case where somebody had a mental illness, and I think it's good practice to allow them. You've just got to remember what they're there for, and if they do get disruptive, you probably need to adjourn to have that conversation with them, but it's always good practice to allow them if they do ask.
I want to squeeze a personal question in here with regard to the going back a while, but with regard to if somebody wants to be accompanied by a trade union official,
yeah,
do they have to be a member of that union?
I think so, yeah. I mean, anybody can join a union. You do have to be a member. I'm sure you do for them to accompany you.
Oh, it resolves the problem I had about 10 years ago. I've just been dying to know. It's a bit late. Better late than never. Okay. Nikki asks, what happens if the employee has started a role and progressed further up the ladder, but has never had a contract put in place, but he's now over the 2 years of employment? Where does that leave the employee? Okay,
I mean, whether there's a contract in place or not, and there is a legal obligation to provide that within 2 months, if they're working towards more implied terms, then there is that contract in place. But I would certainly suggest get a contract drawing up. I mean, the new legislation that came into place last year, it's still in terms of having to provide a contract within 2 months, but you have to provide what they call a Section 1 statement from day one. The only risks really are that if they were to make any other claim, because you can't make a claim about not having a contract on its own, but if they were looking at making another claim, say constructive dismissal, they would also get an uplift if they've never had a contract.
Yeah. Okay. Can you please, Nate asks, can you please clarify what role the additional person joining the companion in a meeting can and can't do? What they're there for? Okay,
well, the main thing is they can't ask questions, they can't answer questions for the employee. So they're there to refer with them, and as long as the employee is happy, they can ask questions during any formal hearing. They just can't answer for the employee.
Right. Okay. Moral support.
Yeah.
Okay. Tracy asks, should return to work interviews be conducted after every absence, or are there guidelines as to when it should take place, a specific length or an amount of time off or something like that?
Yeah, there are no guidelines really. It's up to yourselves how you want to run them. I suppose if you look at it, if somebody's been into work and gone home feeling ill, and then you do a return to work, that could seem as excessive. But return to works are a good way of highlighting any concerns you've got with employees, because you're monitoring the absences. If you've got triggers in place, a further absence at a return to work meeting might be saying, look, you know, you've hit a trigger now, we're going to have to go down a process. But as I said, there are no right and wrongs. That it depends on what you want to do. I would do one after every absence. That's me.
Okay, I suppose whatever fits for your business.
Yeah.
Dola asks, would it be unfair to dismiss based on underperformance if an employee is still within the standard 6 months probationary period?
No, I mean, obviously I'd be asking the question as to whether it's been highlighted to them what the performance issues are, and they've been allowed to give a response, and that any support or training's been put in place. As I say, you've got that flexibility during a probation period to dismiss if you want. But it's more from an ethical point of view. I would say that my advice would be at least give them an opportunity to try to improve before you make that decision.
Okay. Say, I hope I pronounced that right, asks us, an employee, this is very, very topical, an employee has failed to disclose a COVID test result. However, they are also on probation and only recently started. Despite numerous attempts of trying to contact them, which has proved unsuccessful. Are we within our rights to dismiss, or would it be better to follow a fair procedure?
Okay. If they're absent at the moment and you've not been able to get in touch, I think from a duty of care perspective, I was trying to get hold of the next of kin first, just to make sure there isn't any issues, especially if they've just had a COVID test. And it would depend on the reason why they've not been in, but ultimately unauthorised absence can constitute gross misconduct. But again, if they're in a probation, as long as any absence isn't linked to something that could be seen as a disability, then it would still be safe to dismiss. You just need to put it in writing.
Right, there you have it. Thank you. Two final questions, and one of them's my fault. I've opened a can of worms. Debbie says, how do you establish if an employee is a member of a trade union? If a union rep is prepared to represent them, is that presumed membership? Well, in my experience, it's not. It's recruiting for the union. That's what it was in my case. But
yeah, and the thing is, you know, we think back to Thatcher days. You know, it was the done thing that you were in a union and it was recognised within the organisation, and it's not now. And one of their main points is trying to recruit people to join their union, and it's a private agreement, you know, that they pay for as like a direct debit. So unless you ask them, you probably wouldn't know. And unless, you know, if you don't recognise unions, I mean, a lot of the public sector's education now, they recognise unions anyway, and they work very closely with them. But not many private organisations do.
okay, so it's quite a difficult one. You asked them, really.
Well, I mean, in a lot of our standard letters that we send out when we're inviting somebody to a disciplinary, we'd actually put in there, you've got the right to be accompanied by a trade union rep, and ask them to let us know in advance who that companion would be. So then at least you know whether it is going to be a union rep. And I'd certainly ask to see their ID as well when they are present, and make sure that they are recognised.
That's a good point. Saying in a previous life, we permitted union reps to be a companion even when they weren't necessarily a member.
Yeah.
And in all honesty and balance, the union rep probably helped us more than it did the employee.
Yeah.
Because they knew what a fair process was.
Yeah.
You know. Okay, last question from David. If I have to choose between two people, similar skills, length of service, performance, two very similar people, for redundancy due to a required cost saving due to the pandemic, etc., how could I evidence I've made a fair choice?
Okay. It sounds to me that, and again, I don't know the ins and outs, but when you're in a redundancy situation, it's about the role, not the person. So it's if the role is being made redundant. So if you've got two people that are doing the same role, you have to go through a selection process, and your selection will be based on things like skills, performance, and you've got to follow a fair selection process and be able to evidence your scoring, and that is actually shared with the employee as part of the consultation period. So as I say, I don't know enough about this situation and whether they are doing the same role. but you would need to somehow evidence. So if it's based on performance, it could be appraisal documentation, one-to-one reviews, things like that, and any other sort of data that you might have on terms of quality, things like that.
Going to be difficult.
Yeah.
Okay. Someone's managed. Dola has managed to slip one question under my radar. That's after I'll do this one, then no more. It's like I'm auditioning for question time here.
I was going to say, it's really good, is this? I've not been used to doing a webinar with so many questions, so thank you, everyone.
Yeah. I think this is in relation to where you dismiss somebody for underperformance during the 6-month probationary period. It was a question we took a short while ago where you were told, you know, you'd review it, you'd perhaps give them a chance to get better. In that situation, would it be justified to have a salary review, possible salary reduction during that review period? So someone's in the probation, they're not doing it very well, you're thinking of dismissing them, you say, look, we'll give you a few weeks to get better, can you pay them less? And we've given you a month to improve, but you're not delivering what we wanted, so we're going to pay you a bit less until you prove yourself.
Well, the answer is no without consent from the employee, because it's a change to terms and conditions. So if you, and also you've got a risk of an unlawful deductions claim as well. So if somebody's performance wasn't great, and you're giving them the opportunity to perform better, and you want to reduce their salary, then ultimately you'd have to consult with the employee and get their consent. Otherwise, they could put a breach of contract claim in, and as I say, unlawful deductions as well.
Right. Okay. Thank you very much. Well, that draws today's questions to a close. We just had a comment come in from one of our listeners saying, thank you, lots of information, some great questions. And as Wendy says, it's the questions that make it. That's where there's some real learning, and it's where we put our guests on the spot. So thank you, everyone. Please join me in the chat of thanking Wendy for her time and expertise today. It's been really interesting.
Thank you.
If you found this useful, we do have another webinar coming up in 2 weeks' time. I'm just trying to copy the link into the chat for you. Bear with me. There we go, success. If you remember, we are one of our friends from Effective HRM, again, another knowledgeable HR consultancy, are going to be talking about, can you enforce people to take a vaccine? Do you have to continue to employ them if they refuse to take the vaccine? And so on and so on. And this is an evolving hot potato. The last 3 days, the advice has changed. I've been watching this. Personally, as soon as they offer me one, I'm taking it. I'll have to. But for reasonable issues, some people may not want to, may not be able to. So tune in on the 24th to hear about that. As I said earlier, we'll be sending a follow-up to this. We'll be sending you a recording. We'll send you some slides and some content and the dates of some upcoming webinars. So just falls to me to say thank you very much for your attendance today. I hope you have a great day. Thank you.